Hello friends, welcome back to series of lecture. This is the 52nd lecture of this series of Indian Evidence Act, and in this lecture we would continue with section 33. So it is saying evidence given by a witness in judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the same judicial proceeding the truth of the fact the truth of the facts which it states when the witness is dead or cannot be found, or is incapable of giving evidence, or is kept out of the way by the adverse party, or if his presence cannot be obtained without an amount of delay or expense which under the circumstance of the case the court considers unreasonable. तो इसका जो लास्ट पार्ट तो वैसे ही होगा जैसे सेक्शन 32 का जो फर्स्ट पैराग्राफ में दिया है. If he dead or cannot brought to the court without expenses, cannot found, incapable of giving evidence, etc. तो इसमें एक दो पॉइंट्स ऐड किया है that adverse party is not allowed in the case. तो ये एक पॉइंट ऐड किया है, otherwise the same as 32 para 1. Now what they are saying is, look at the first part again up to here. So, evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later stage of the judicial proceeding the truth of the fact which it states etc. अब इसमें मेन जो आपको समझना वो ये है, मानो एक प्रोसीडिंग्स है ए और बी के बीच, क्रिमिनल ट्रायल और सिविल वॉटएवर, एक प्रोसीडिंग्स ए और बी के बीच. अब इसमें ट्रायल के समय कोई एक एक्स है जो विटनेस बनकर प्रेजेंट हुआ. In that case, X appears as a witness and he makes some statement. X made some statement. If thereafter, suppose trial is over and the judgment is passed. If the witness's statement is recorded, you know that the witness had given the statement on oath, and you also appreciate that the witness's cross-examination may have been done. Witness जो evidence देगा उसको proof करना पड़ेगा. अब proof कैसे होगा? Examination in chief, after that cross examination in chief, and after that cross examination. So all that was done. After that the witness testimony is said to be proved. Now this case is over. Now again tomorrow suppose this A and B same parties regarding the same matter in issue again suit or proceeding करते हैं. Then in this trial also the same witness is to be required because the evidence is on the same fact. अब इधर ये मत सोचना कि रेस जूडिकाटा लग जाएगा एक्सेट्रा एक्सेट्रा. मान लो रेस जूडिकाटा नहीं लगाया और दोबारा ट्रायल हो गया, अब उसी मैटर पर एक्स को फिर से एविडेंस देना है, लेकिन इस बार एक्स इज एब्सेंट, एक्स इज एब्सकॉन्डिंग, एक्स इज मिसिंग, ही कैन नॉट बी फाउंड, और मे बी ही इज डेड, or maybe opposite party is not allowing X to be appear into the court. Can the court in this case take this statement as a piece of evidence? जो पिछले केस में उसी मैटर पर X ने उन्हीं पार्टीज के बीच X ने उसी मैटर पर जो एविडेंस दिया था, क्या कोर्ट उसी एविडेंस को अब इस वाले सूट में या प्रोसीडिंग में यूज कर सकता है अगर X मर गया है या फिर X कैन नॉट ब्रॉट एक्सेट्रा. सो व्हाट द सेक्शन सेज फॉर दिस? सेक्शन सेज यस. देखो उसको दोबारा, बिकॉज सेक्शन सेज एविडेंस, यूजिंग द वर्ड एविडेंस, इट इज यूजिंग द वर्ड एविडेंस, इट इज नॉट अ प्रीवियस स्टेटमेंट, एंड एविडेंस मीन्स व्हाट? समथिंग यू आर गिवन इन द कोर्ट. तो आपने कोर्ट में खड़े होकर बयान दिया है, you had given the testimony in the court and you are subjected to the cross examination, or at least the opportunity of cross examination was given to the party concerned. So they are saying evidence Evidence given by a witness in judicial proceeding means what? In the court or before any person authorized by law to take it. What is mean by that? अब कोर्ट का तो इसमें कवर हो जाएगा इन द जुडिशियल प्रोसीडिंग्स, सिविल हो या क्रिमिनल हो। अब इसका क्या मतलब हुआ ऑथराइज्ड बाय लॉ, एनी पर्सन ऑथराइज्ड बाय लॉ। अब देखो कई बार कोर्ट अपने आप एविडेंस रिकॉर्ड नहीं करती, एविडेंस रिकॉर्ड करने के लिए कमीशन भेजती है। जैसे सीपीसी में ऑर्डर 18 रूल 4 है, तो वहां पर इसी कमीशन की बात हो रही है, दैट द कोर्ट मे सेंड कमीशन टू एग्जामिन द पर्टिकुलर विटनेस, may send commission to examine the particular witness. So the witness appear in the court and either he gave the evidence in the court itself or he is examined by a commission. Now they are saying evidence given by a witness, and obviously you understand that evidence always given on oath. Evidence given by a witness in a judicial proceeding or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in later stage of the same judicial proceeding the truth of the facts which it states when the witness is dead or cannot be found or is incapable of giving evidence। मान लो अनसाउंड हो गया और is kept out of the way by the adverse party, or if his presence cannot be obtained without an amount of delay or expense which under the circumstances of the case the court considers unreasonable। उस केस में फिर उसी सूट के सब्सिक्वेंट स्टेजेस, जैसे मान लो अपील वगैरह में, उसी विटनेस को बुलाना है दोबारा, लेकिन विटनेस आ नहीं सकता है नहीं, तो फिर उस सिचुएशन में क्या उसने जो पहले बयान दिया था क्या दोबारा उसी को एडमिट कर सकते हैं? द आंसर इज यस। अब उस सूट में ए और बी के बीच एक्स ने विटनेस बनकर बयान दिया, अब दोबारा ए और बी के बीच में अगर सूट हो जाए या प्रोसीडिंग हो जाए, अब उसी बात पर एक्स का दोबारा बयान करवाना है, तो जनरल रूल तो ये है कि आप उसको दोबारा बुलाइए, लेकिन मान लो ही इज नॉट अवेलेबल, ही इज डेड एक्सेट्रा, then can you admit his statement that he has made in the form of suit or proceedings? Answer is yes. Can you admit his statement which he has made in the form of suit or proceedings? So it will be admitted. लेकिन उसकी कंडीशन से, कंडीशन देख लो आप, provided that the proceeding was between the same parties or their representatives in interest. दैट मीन्स अगर प्रोसीडिंग पहले जो प्रोसीडिंग्स हुआ था वो ए एंड बी के बीच हुआ था, दैट शुड ऑल्सो बी इन बिटवीन ए एंड बी, और या फिर उनमें से कोई मर गया तो दे आर रिप्रेजेंटेटिव इन एन इंटरेस्ट। सो द प्रेजेंट सूट और प्रोसीडिंग्स, so the present proceedings was also between the same parties or their representative in an interest, then that the adverse party in first proceeding had the right and opportunity to cross examine। अब जब ये विटनेस पहले कोर्ट में गया था बयान देने, तो उसका जो एविडेंस है वो प्रूव्ड कब माना जाएगा? when he was subjected to cross examination, or at least the opposite party has given the right to cross examination, maybe they say that I do not want to cross examination, लेकिन कम से कम उसको मौका मिला हो क्रॉस एग्जामिनेशन का। So he had given the right to cross examine and he actually did it or not, that is immaterial. That the adverse party in the first proceeding had the right and opportunity to cross examine, that the question and issue were substantially the same in the first as in the second proceeding। मतलब जिस मैटर पे उसने एविडेंस दिया है और जो ब्रॉड सब्सटेंशियल इशू हैं, दे शुड बी द सेम। तो ये सब है रेस जुडिकाटा में, दैट द मैटर्स शुड बी द सेम और एट लीस्ट द सब्सटेंशियली बी द सेम। नाउ एक्सप्लेनेशन, अ क्रिमिनल ट्रायल और इंक्वायरी shall be deemed to be a proceeding between the prosecutor and the accused within the meaning of this section. अब क्रिमिनल ट्रायल में पार्टीज कौन होंगी ये बताओ. द पार्टीज आर प्रोसिक्यूटर एंड द accused. Prosecutor is the one party and the accused is the other party. Prosecutor is one party and accused is another party. अब देखो कई बार यहाँ पे ये कंफ्यूजन हो जाता है, जैसे 164 का बयान सीआरपीसी और 161 सीआरपीसी के स्टेटमेंट. तो इस तरीके के स्टेटमेंट, वेदर दे आर स्टेटमेंट्स इन 161 सीआरपीसी, 164 सीआरपीसी, अब will they also fall under section 32? Sorry, this section 33. Now you see the word used is evidence. When you make the statement before the judicial magistrate under 164, that is not evidence. That is just a statement or confession. When you made the statement to the police under 161, that is not an evidence. Evidence means formally in the court at the trial stage, either before the court or before a commission. You make a statement on oath and you have been subjected to the cross-examination, or at least right to cross-examination is given to the opposite party. Then you can say that it is a piece of evidence. So इसीलिए 164, 164 या 161 के बयान पर सेक्शन 33 विल नॉट अप्लाई. अब इसको ऐसे समझो, मान लो तुम विटनेस हो और तुम हाई कोर्ट में, तुम्हारा एग्जामिनेशन ऑफ चीफ होगा. अगर सिविल मैटर है तो एफिडेविट पे एग्जामिनेशन इन चीफ कर लोगे, और क्रिमिनल मैटर है तो एग्जामिनेशन होगा. अब एग्जामिनेशन इन चीफ होगा इन अदर वेज. तुमने बयान दिया किसी फैक्ट पर, तो उसका क्रॉस एग्जामिनेशन अपोजिट पार्टी करेगा. तो उसने सवाल पूछा और तुमने जवाब दिया, और फिर जो पार्टी तुमको लेकर आई थी क्रॉस एग्जामिनेशन के बाद, वो चाहे तो वो री एग्जामिन करे आपका. अब ये कंप्लीट होने के बाद तो अल्टीमेटली एक फैक्ट प्रूव या डिसप्रूव हो गया. अब वी टॉक अबाउट इफ द फैक्ट इज प्रूव्ड आफ्टर द क्रॉस एग्जामिनेशन एंड ऑल प्रोसीजर. अब टुमारो इफ इन द सेम केस or maybe in some other case between the same parties, once again on the same matter, you are required to give evidence. But you have gone abroad, you have not there, you have settled somewhere in India and you are not willing to come. You are not willing to come also. तो आप विदेश चले गए, वहाँ पर सेटल हो गए हो, and you are not willing to come in India. अगर इंडिया में हो तो फिर तो कोर्ट सम्मन और वारंट कर सकती है, and may court brought you. But when you are abroad, or there are other reasons which is provided in this, due to which you cannot come, so in that case, in that other suit or proceeding, then will the evidence that was given by you in the former court, will that be allowed to be proved? Will that be allowed to be proved? Answer is yes. So answer is yes. अब देखो, if the witness is given the evidence, means it is proved. Examination, cross examination, re-examination. अब re-examination में, cross examination में, एग्जामिनेशन इन चीफ में मान लो 50 सवाल पूछे हैं आपने. अब क्रॉस एग्जामिनेशन में डिफेंस ने मान लो 5 सवाल ही पूछे. तो अब अगर जो री एग्जामिनेशन होगा, तो री एग्जामिनेशन में वो 50 सवाल नहीं पूछेंगे जो एग्जामिनेशन इन चीफ में हुए. सिर्फ जो 5 सवाल क्रॉस एग्जामिनेशन में जो पूछे गए उसी से रिलेटेड री एग्जामिनेशन होगा. सो इफ द विटनेस इज गिवन द एविडेंस एंड दैट एविडेंस इज प्रूव्ड आफ्टर क्रॉस एग्जामिनेशन वगैरह, तो या तो हो गया है वो क्रॉस एग्जामिनेशन, या फिर अपॉर्चुनिटी मिल गई है डिफेंस को, पार्टी ने किया नहीं है, एन अपॉर्चुनिटी वाज गिवन. सो नाउ इन द सेम केस और इन सम अदर केस ही कैन नॉट अपीयर. Same case or some other case he cannot appear. So in that case, will that earlier evidence be used directly? The answer is yes, provided that condition देखो, the parties, the proceedings was also between the same parties or their representatives. Number 2, that in the former suit or proceeding it was proved. मतलब क्रॉस एग्जामिनेशन हो चुका है, या एटलीस्ट राइट टू क्रॉस एग्जामिनेशन अपोजिट पार्टी को मिल चुका है। एंड नंबर 3, द क्वेश्चन इन इशू वर सब्सटेंशियली द सेम इन द फर्स्ट एज इन द सेकंड प्रोसीडिंग। और इसमें 161 और 164 वगैरह फॉल नहीं करेंगे बिकॉज दिस इज द स्टेटमेंट, दिस सेक्शन अप्लाई टू द स्टेटमेंट्स which are made only in the judicial proceedings, in the court in a judicial proceeding, and not upon the statements which is made to the judicial magistrate in 164 etc. Now let's see example. A और B के बीच में एक केस चल रहा है, मान लो डिफेमेशन का केस है। डिफेमेशन क्रिमिनल में भी हो सकती है और सिविल में भी हो सकती है। अब क्रिमिनल का डिसाइड हो गया ए और बी के बीच में। एक विटनेस आया ए के बिहाफ पे डब्ल्यू, एंड उसका विटनेस एग्जामिनेशन हो गया, एज एविडेंस एक्सेप्ट हो गया। नाउ ये क्रिमिनल केस डिसाइड हो गया, अब सिविल केस चल रहा है। अब इन द सिविल केस ऑल्सो he has to get the evidence about the same fact whether he has made the statement so and so। अब वही फैक्ट का एविडेंस डब्ल्यू को यहाँ पर भी सिविल केस में भी देना है कि वेदर डिफेमेशन का स्टेटमेंट वाज मेड बाय बी और नॉट। बट सपोज बाय दैट टाइम डब्ल्यू वाज डेड। अब द पॉइंट इज कैन दिस एविडेंस व्हिच इज मेड बाय डब्ल्यू, सो उस एविडेंस में क्रॉस एग्जामिनेशन एवरीथिंग वाज डन, तो कैन दिस एविडेंस ऑफ डब्ल्यू हियर इन दिस केस सिविल केस बी यूज्ड एज अ पीस ऑफ एविडेंस डायरेक्टली? आंसर इज यस। तो समझ में आया, एक सिविल है और एक क्रिमिनल है, फिर भी द आंसर इज यस। तो ये पॉइंट आपको ध्यान रखना पड़ेगा। ऐसा नहीं है कि सिविल केस का ही सिविल में एविडेंस अलाउड होगा, सिविल का क्रिमिनल में भी हो सकता है, प्रोवाइडेड द फैक्ट इज द सेम। वही चीज एक्सप्लेनेशन में लिख रहा है, ए क्रिमिनल ट्रायल और इंक्वायरी शैल बी डीम्ड टू बी ए प्रोसीडिंग बिटवीन द प्रोसिक्यूटर एंड द अक्यूज्ड विद इन द मीनिंग ऑफ दिस सेक्शन। अब सपोज कंप्लेनेंट केस में complainant and the accused they are the parties and same persons are the parties in the civil case. So criminal trial में जो evidence दिया था that witness died or could not be found, then that evidence could be used in the civil trial directly. So this is about this section. And we had seen that in a criminal proceedings, if a statement is made, then it can be used in civil, or if civil, that evidence, if evidence is used, that can be used in criminal. So vice versa, either ways. And there are several cases in which criminal and civil liability both arose, जैसे defamation case है, tortious liability या tortious liability, and so forth. Tort में तो लगभग सारे ही हैं, in which civil and criminal are fall. Now let's start from section 40 to 44, relevancy of previous judgments. Please take out section 40. Section 40. The existence of any judgment, order or decree which by law prevents any courts from taking cognizance of a suit or holding a trial is a relevant fact when the question is whether such court ought to take cognizance of such suit or to hold such trial. Ought to take cognizance of such suit or to hold such trial. Now see what they are talking about here is, in the CPC, provisions like section 11 or sections like res judicata or you relinquish a relief and you do not file suit. अब मान लो पहले ए और बी के बीच में एक जजमेंट आ चुका है. Now tomorrow there is again a suit between A and B raises the objection of res judicata. Will this previous judgment be relevant to prove the res judicata in this suit, in present suit? Answer is yes. Similarly, will the previous judgment will be relevant to prove the application of order to rule to here? So अगर किसी suit में bar है, if there is subsequent suit which is barred and there is a former suit which is already heard and decided, then the previous judgment can be used in the subsequent suit which proves the bar. उसी तरीके CRPC में you may have read section 300. It clearly says that if there was trial against A and if it is decided, then a subsequent trial against A is barred. मीन्स यदि एक व्यक्ति के खिलाफ एक बार ट्रायल खुल चुका है, एक व्यक्ति के खिलाफ ट्रायल हो चुका है, तो वो जजमेंट जब तक फोर्स में रहेगा, तब तक it cannot be a trial against that person for the same offense. That is written in section 300. If a person is tried and convicted or acquitted in a criminal court, then as long as that judgment remains in force, a subsequent trial of that accused for the same offense is prohibited. Now suppose A was tried first for the offense of death, where he was convicted. A was tried and he was convicted, then he cannot be tried once again. अब डेथ के केस में तो मे बी लाइफ इम्प्रिजनमेंट हो सकती है. अब सपोज इफ ए इज ट्राइड फॉर द थेफ्ट and convicted for the same offense, for one offense, then he cannot be tried for that same offense under same FIR if he was already convicted or acquitted also. So as long as this judgment remain in force, the subsequent trial will be barred. अब जैसे ही ये दूसरा ट्रायल शुरू होगा, he will produce the copy of the previous judgment and he will prove into the court that I had been already tried and convicted or acquitted, whatever the judgment in this case, and now I will not be tried again. The bar of section 300 will apply. So in these cases, whether the triability of person or whether the triability of the suit in the subsequent suit or proceeding is in question, then the previous judgment will become relevant to prove the bar of law. फिर से पढ़ लो एक बार इस सेक्शन को. The existence of any judgment, order or decree which by law prevents any court for taking cognizance of a suit or holding a trial. Of civil law में res judicata, order to rule 2 etc., order 22 rule 9. Now there are many provisions in CPC which prevents the subsequent trial. Similarly एक compromise degree हो गया तो दोबारा उसी मैटर पर ट्रायल नहीं हो सकता, ऑर्डर 23 रूल 3A. सो ओवरऑल कोई सूट या प्रोसीडिंग डिसाइड हो गया तो देयर आर लॉज which prevents the subsequent suits between the same parties and the subject matter, which prevent the subsequent trial. In criminal matters that is 300 CRPC, and in CPC civil matters there are different provisions like order 23 rule 3A, section 11 CPC, order 2 rule 2 etc. So these are certain provisions which prohibit the subsequent suit in CPC. So in such cases where the subsequent suit is filed, in such cases the former judgment will become a relevant fact because that will prove that the bar will apply upon the subsequent suit or not. अब एक एग्जाम्पल देख लेते हैं. ए और बी के बीच सूट हुआ and it is finally heard and decided. The judgment was passed. The suit was passed in favor of A. B again filed a suit on the same subject matter. All the matters in the issue were same and in the same legal capacity they are. A will raise the objection of res judicata or not. In order to prove the res judicata, will he not required to prove the copy of the previous judgment कि मेरे और इसके बीच पहले का डिसीजन आ चुका है, तो ये जो प्रीवियस जजमेंट है ये रेस जुडिकाटा प्रूव करने के लिए रेलिवेंट हो जाएगा. Similarly any other bar you can prove. Now see section 41. A final judgment, order or decree of a competent court in the exercise of probate, matrimonial admiralty or insolvency jurisdiction which confers upon or takes away from any person any legal character, or which declares any person to be entitled to any such character, or to be entitled to any specific thing, not as against any specified person, but absolutely, is relevant when the existence of any such legal character or the title of any such person to any such thing is relevant. फिर से पढ़ रहा हूँ. A final judgment order or decree of a competent court. मतलब पहले जिस कोर्ट ने डिसाइड किया था दैट वाज कॉम्पिटेंट कोर्ट, और उस कोर्ट ने किसी मैटर को फाइनल जजमेंट ऑर्डर या डिग्री पास कर दिया. किसी मैटर पर फाइनल जजमेंट ऑर्डर या डिग्री पास कर दिया कॉम्पिटेंट कोर्ट ने. फॉर एग्जांपल ए और बी के बीच एक सूट था दैट वाज इन अ कॉम्पिटेंट कोर्ट. देयर वाज अ सूट बिटवीन ए एंड बी एंड विच वाज इन कॉम्पिटेंट कोर्ट, और उस सूट में कोर्ट ने फाइनल डिग्री पास कर दी है बिटवीन ए एंड बी, और अ फाइनल जजमेंट हैज बीन पास्ड बिटवीन ए एंड बी. A final judgment order or decree of a competent court in exercise of a probate, matrimonial, admiralty, or insolvency jurisdiction. So you see, in 41 they are talking about four kind of courts. One is probate, then matrimonial, admiralty, and then insolvency. Now ये section 41, this will apply upon these courts. The probate court is a court which issues the certificate regarding the will. तो कोई भी कोर्ट जो विल के मामले में सर्टिफिकेट इशू करेगा दैट विल बी कॉल्ड प्रोबेट. मैट्रिमोनियल यू अंडरस्टैंड मैरिज एंड डिवोर्स, मैरिज रिलेटेड इश्यूज. एंड एडमिरल्टी इज अबाउट नेवल मैटर्स, जो नेवी से रिलेटेड मैटर्स होंगे. अब जैसे कोई अदर कंट्री के मछुआरे इंडिया में आ जाएं या फिर कोई, तो दे विल बी ट्राइड इन द एडमिरल्टी कोर्ट. So these kind of cases relating to fishing, sea, they will be tried by the Admiralty Court. So insolvency, you understand, a person who becomes insolvent, जिसके पास ऐसा person जिसके पास कर्जा ज़्यादा और प्रॉपर्टी कम है, he will become insolvent. So any court which declares a person to be insolvent. So these four types of courts they are talking about. So इनमें से किसी कोर्ट में किसी पार्टीज के बीच फाइनल जजमेंट या डिग्री पास किया था उसकी बात कर रहे हैं. इनमें से किसी कोर्ट ने किसी पार्टीज के बीच फाइनल जजमेंट डिग्री या ऑर्डर पास किया था. दे आर टॉकिंग अबाउट दैट इन पर्टिकुलर. सो a final judgment order or decree of a competent court in exercise of probate, matrimonial, admiralty or insolvency jurisdiction, which confers upon or take away from any person any legal character, or which declares any person to be entitled to any such character, or to be entitled to any specific thing. Means the judgment is such which declares that such person has such and such legal right, legal character, or declares that this person's legal right is taken away. तो किसी का राइट हटा देना तो उसके बारे में डिक्लेयर कर देना, या फिर किसी एक व्यक्ति का किसी ऑब्जेक्ट पर राइट है वो डिक्लेयर कर देना. जैसे मैट्रिमोनियल प्रोसीडिंग्स में हस्बैंड वाइफ के बीच में डिवोर्स हुआ, सो दैट डिवोर्स डिक्री दैट डिक्लेयर्स द लीगल कैरेक्टर ऑफ दोज पर्सन्स मीन्स दैट दीज आर नाउ onwards no more husband wife. Now similarly a person got a probate in his favor, probate degree means now onwards means this man is having right upon so and so thing now onwards. So उस तरीके का कोई भी judgment होगा, then they are saying as further that not as against any specified person but absolutely is relevant when the existence of any such legal character or the title of any such person to any such thing is relevant. Now they are saying absolutely. What do you mean by absolutely? So what do you mean by absolutely? They are saying here. Now you see that there are two types of judgment. One is judgment in personam. and the other is judgment in rem. अब ये जो सेक्शन है that is related to judgment in rem. So absolutely means with respect to world at large. अब मान लो दो व्यक्तियों के बीच में डिस्प्यूट हो जाए किसी मकान को लेकर and the court passes the decree that this house belongs to A and the suit is between A and B. So that is not the judgment in rem. That is the judgment in personam because that is only between A and B. Of tomorrow if the third person comes and he is having a better title, then the court will pronounce a decree in whose favor? That third person. So it is judgment in personam. Similarly, suppose there is a contract between me and you and I have done the breach of contract and you get the damages from the court if I done the breach, or if you do the breach then I got the damages from the court. So that is judgment in personam. So that is judgment in personam. लेकिन judgment in rem वो होगा that is binding upon the whole world. For example, A got a decree of probate in his favor. अब this probate is against the world at large. अब किसी ने मेरे नाम पे वसीयत बना दिया, someone has made a will in my favor and I go to the probate court to have the probate declared. अब कोर्ट ने मेरे फेवर में probate declare कर दिया. The court has declared the probate in my favor. But उसके पहले court will give the notice to the people at large. अब once the probate is declared in my favor means what? That to the whole world it is declared that he is the owner of the so and so property. उसी तरीके से मान लो हस्बैंड एंड वाइफ के बीच में डिवोर्स हो जाए. अब है तो सूट इन पर्सोनम. हस्बैंड कैन फाइल द सूट अगेंस्ट वाइफ एंड वाइफ कैन फाइल द सूट अगेंस्ट हस्बैंड. लेकिन एक बार डिक्लेयर हो जाए दैट दे आर डिवोर्स्ड मीन्स व्हाट? द फैक्ट दैट दे आर नो मोर हस्बैंड एंड वाइफ दैट इज बाइंडिंग अपॉन द होल वर्ल्ड और नॉट. सूट तो एच और डब्ल्यू के बीच हुआ लेकिन एक बार ये डिक्लेयर हो जाए दैट दे आर नो मोर हस्बैंड एंड वाइफ, दे आर डिवोर्स्ड. सो द फैक्ट दैट दे आर डिवोर्स्ड दैट इज बाइंडिंग अपॉन द होल वर्ल्ड. आपस में दे आर नो मोर हस्बैंड एंड वाइफ बट कल को हर व्यक्ति के लिए फ्रॉम दैट डेट दे विल बी कंसीडर्ड not to be husband and wife. So that will be considered to be a judgment in rem. So judgment in rem means the point is any court which is admiralty court, which is probate court, it is a matrimonial court or insolvency court. If it passes judgment between the parties and the nature of the judgment is if it passes the judgment in between the parties and the nature of the judgment is judgment in rem. The nature is that it is the judgment in rem. Now in that case, tomorrow there is suit between any person, not the same parties only. A suit between any person, and in that suit, a question arises regarding that particular judgment. Then that previous judgment will be a relevant fact. तो जैसे मान लो H और W are husband and wife. Now there is a petition and divorce was obtained. डिवोर्स हो गया. अब मान लो इस डेट पे डिवोर्स हो गया एंड आफ्टर समवेयर हेयर एच डाइज. अब एच के मरने पर एच की जो एक्स वाइफ है शी वाज होल्डिंग अ प्रॉपर्टी अ हाउस विच इज बिलोंग टू एक्स एच एंड द मदर ऑफ एच शी इज claiming that this house belongs to me because I am class 1 year. And you are not wife, you are divorced, so you will not get anything from it. Now W is not getting the property. W is not giving the property to M, mother of H. So M filed suit against W. मदर ने फाइल किया एक्स वाइफ पर, मदर क्लास 1 ईयर है, मदर ने फाइल किया W पर दैट आई नीड द पोजेशन ऑफ द प्रॉपर्टी. अब यहाँ पर एक इशू उठा, is W a lawfully wedded wife of H? Now can M produce the previous judgment of divorce? अब यहाँ पर parties are not H and W. Parties are not in the subsequent suit. Parties are not the H and W. अब W तो मान लो चलो wife है लेकिन M is a third person. तो उनके सूट में भी in that suit also the judgment of the matrimonial court regarding the divorce will be a relevant fact and that judgment can be used. लेकिन अगर ये जजमेंट इन पर्सोनम होता तो फिर ये किसी और पार्टी के केस में रेलिवेंट नहीं होता, लेकिन क्योंकि ये जजमेंट इन रेम है देयरफॉर इट विल बी relevant in this suit between M and W, and that is the judgment in rem passed by the matrimonial court. इस एग्जाम्पल पे लिख लो आप, राइट डाउन वन पैरा. In above case, in this example, in above case, the judgment of divorce between H and W, husband and wife, is a judgment in rem, and in the subsequent suit for the property between M and W, mother of H and W, ex-wife of H, even though they were not party to the former suit in the previous judgment between H and W, will be relevant, as it was a judgment in rem passed by the matrimonial court. Section 41 provides for relevancy of judgment in rem only. 41 provides relevance of judgment in rem only, and that to either of the four courts. Four courts मैंने already बता दी कौन कौन सी हैं. Such a judgment will be relevant not only between the parties to the former suit, rather also between any third persons. Read it once again. A final judgment, order or decree of a competent court in exercise of probate, matrimonial, admiralty or insolvency jurisdiction, which confers upon or takes away from any person any legal character, or which declares any person to be entitled to any such character or to be entitled to any specific thing, not as against any specified person but absolutely, is relevant when the existence of any such legal character or the title of any such person to any such thing is relevant. Now what they are talking about is, suppose there was a suit between A and B, and in that suit a decree was passed, and the decree either taken away the right from any legal right from either of these parties, or it has declared existence of a legal right, or it has conferred a legal right upon a party. या तो इस डिक्री में किसी व्यक्ति का either of these parties the right has been taken away, or the right has been declared to be existing, or it has conferred the right upon that party, and that right may be a personal right, or the right may be with respect to some object, property or thing. Now what they are saying is, if this decree is passed by admiralty court, insolvency court, probate court or matrimonial court, and the decree was of a absolute nature, absolute means what? Judgment in rem, then in subsequent suit, even if the subsequent suit is between C and D, means with some third person, and in that suit the question of such right etc. has arises, then this formal judgment will be relevant in this suit, because that will be an absolute judgment, that will be judgment in rem, that will be binding upon the whole world at large, and therefore it will be relevant in subsequent suit. And it is not necessary that the subsequent suit should have been between the same parties. अब इसमें मैक्सिम लिख लीजिए, res inter alias acta alterae nocer non debit. Res inter alias acta alterae nocer non debit. इसमें लिखिए, write down. This means a matter transacted between one set of persons will not affect another set of persons. Means what? अगर A और B के बीच में जजमेंट है तो वो सी और डी को अफेक्ट नहीं करेगा। जबकि 41 इज व्हाट, 41 इज सेइंग दैट विल बी रेलिवेंट इन सी एंड डी वाला केस ऑल्सो। सो सेक्शन 41 इज एन एक्सेप्शन टू दिस मैक्सिम। सो इसको भी लिख लीजिएगा आप, राइट डाउन। सेक्शन 41 is an exception to the above maxim. The rationale behind section 41 is that the judgments which are of an absolute nature, that is judgment in rem, will be binding not only between the parties, rather it will be binding upon the whole world at large, and therefore in the suit between third parties also the previous judgment will be binding. It is essential for section 41 to apply that the judgment was passed by admiralty, probate, insolvency or matrimonial court. It is essential for section 41 to apply that the judgment was passed by admiralty, probate, insolvency or matrimonial court, and the judgment was judgment in rem. The judgment should have declared any existence or non-existence of any right of a party in reference to any legal character or with respect to something, or it may have conferred any such right or may have taken away the right. Right, next sentence. If in a subsequent suit between any third persons the same right comes into question, then the previous judgment will be relevant. Why? Because it is a matter of public policy. जो भी आपने पढ़ा दैट इज मैटर ऑफ पब्लिक पॉलिसी। अब मान लो कोई एक राइट है जो डिसाइड हो गया और वो पूरे पब्लिक एट लार्ज के लिए दैट इज डिसाइडेड, then in that case obviously in a subsequent suit, even though there are third persons are involved, then that particular right will be, for that particular right the previous judgment will be relevant. So that is a matter of public policy. Now you see the next paragraph. अभी तक तो सिर्फ इन्होंने रेलिवेंसी की बात की है. The first paragraph they are talking about the previous judgment being to be relevant, but in the second paragraph they are talking about the conclusive proof. And section 112, section 113 and section 41, these three sections are related to conclusive proof. 112 पढ़ा चुका हूँ मैं, 113 आप पढ़ लेना अपने आप, and 41 we are discussing right now. 41 में first para is talking only about the relevancy of the judgment, but second paragraph talking about the conclusive proof. So it is saying such judgment, order or decree is conclusive proof. So such judgment, order or decree is conclusive proof. Is conclusive proof that any legal character which it confers accrued at the time when such judgment, order or decree came into operation. That any legal character to which it declares any such person to be entitled accrued to that person at the time when such judgment, order or decree declares it to have accrued to that person. That any legal character which it takes away from any such person ceased at the time from which such judgment, order or decree declared that it had ceased or should cease. And that anything to which it declares any person to be so entitled was the property of that person at the time from which such judgment, order or decree declares that it had been or should be his property. तो इसको आपको 2-3 बार ध्यान से पढ़ना पड़ेगा, but the point is very simple. They are simply saying that it was a judgment in rem and it has been declared by a court. अब obviously it is subject to appeal. जब भी judgment होगा that is always subject to appeal, but any judgment which is passed, suppose court passes a decree of divorce between husband and wife, the court passes a decree that husband and wife are divorced, then in that case the judgment will be a conclusive proof of the fact that from this date, from today, they are no more husband and wife. from which the decree was passed. Similarly, suppose if a judgment is passed that A was the owner of the particular property, and that was suppose a judgment in rem, then in that case the previous judgment will be a conclusive proof of the fact that from a particular date on which the decree was passed, this person was the owner of the property. Now suppose a person has will and judgment is passed today, तो विल के प्रोबेट के केस में तो प्रोबेट का जो डिग्री है वो आज प्रेजेंट डेट में पास होगा, लेकिन सपोज द वसीयत करता लेगेटर ही डाइड सपोज 1 year ago, but today if the court certifies the will, so the probate will declare what, that the will was effected from the date when the legator dies, जिस दिन वो मरा था. Therefore that judgment in rem in the probate, the judgment in rem in the probate is a conclusive proof of the fact that this person is the owner of the property specified in the will. From what date? Not from the date today, but from the date when the will was effective, that is when he died, legator died. तो यहाँ पर सिर्फ ये डिक्लेयर कर रहे हैं क्योंकि ये जजमेंट इन रेम है, किसी व्यक्ति के ऊपर एक राइट कन्फर कर रहा है या किसी एक व्यक्ति का राइट एक्नॉलेज कर रहा है या किसी व्यक्ति का राइट वापस ले रहा है या किसी व्यक्ति का एक सब्जेक्ट के ऊपर राइट क्रिएट कर रहा है. सो दैट जजमेंट विल बी अ कंक्लूसिव प्रूफ ऑफ टू थिंग्स. वन you have the right or you do not have the right, etc. And two, the date on which such right was declared or such right was created. अब husband wife के केस में the divorce is today, therefore from the date of the judgment the divorce will be effective, and therefore it is conclusive proof from so and so date. If suppose it is done today, then from today's date these two are no more husband and wife. Now suppose if wife goes for a declaration that he is my legally wedded husband, the wife goes for a declaration that he is my legally wedded husband, presuming that it is a matrimonial matter, presuming that it is a judgment in rem. A court declares from so and so date H has been the husband of W. Now if it is a judgment in rem, then it will become a conclusive proof. Conclusive proof of what? Of the fact that they are lawfully wedded husband and wife from that particular date on which the from that particular date it was proved that they are lawfully wedded. So divorce के केस में तो जिस दिन जजमेंट पास हुआ उस दिन से नहीं रहेंगे, और जब लीगली हस्बैंड एंड वाइफ का डिक्लेरेशन होगा तो उस केसेस में जिस दिन के लिए डिक्लेरेशन मांगा होगा, जिस दिन से प्रूव हो जाता है कि दे आर हस्बैंड एंड वाइफ लीगली वेडेड, तो उस दिन से ये लागू होगी डिग्री. सो बेसिकली द थिंग्स यू रीड हियर that is all related to the date as well as the legal character of the person. If you read it again, such judgment, order or decree is conclusive proof that any legal character which it confers accrued at the time when such judgment, order or decree came into operation. That any legal character which it confers accrued at the time when such judgment, order or decree came into operation. तो ये टाइम के बारे में. That any legal character to which it declares any such person to be entitled, ये पर्सन के बारे में, any such person to be entitled accrued to that person at the time when such judgment, order, decree or declares it to have accrued to that person. तो वो जजमेंट में जो डेट लिखा है उसी डेट पे तो राइट एक्रू करेगा. अब मान लो जजमेंट के दिन से ही राइट क्रिएट हुआ तो जजमेंट का डेट विल बी रेलिवेंट, और अगर जजमेंट में लिखते हैं कि 2 साल पहले से वो राइट है, डेट लिखा है जजमेंट में, देन उस दिन से दैट राइट हैज़ बीन एक्रूड. अब मान लो जजमेंट आज पास हुआ तो आज से ही अगर वो राइट क्रिएट हुआ है तो दैट विल बी अ कंक्लूसिव प्रूफ ऑफ द राइट फ्रॉम टुडे. But if the judgment says that right existed from 2 years back, then it is a conclusive proof of the right from 2 years back, and so forth. So ये तो बोल रहा है कि at the time of the judgment, and in this, to that person at time when such judgment orders or decree declares it to have accrued to that person. So these two are of giving of the rights. Similarly here, it is for taking away of right, which takes away from the right. Seed at the time from which the such judgment order or decree declares that, जिस टाइम से वो डिक्लेयर करेगा ऑर्डर, इट हैड बीन सीज्ड और शुड सीज. सो इस पे एक सेंटेंस लिख लो. The latter part of section 41 also relate to the fact that it was a conclusive proof. It was a conclusive proof of the right accruing or right declare और right taken away. तीन चीज आएंगी, accruing, और right declare और right taken away from the date specified in the judgment. So that's all for this section and this class also. In the next class we would continue with section 42. Thank you.